So most entrepreneurs will approach their legal contracts like ordering from a menu. They'll pick clauses they think sound protective and hope everything looks up. Contracts that protect your business are focused on strategic decisions that have got nothing to do with legal language. Your financial structure of your business and what your needs are, that's going to really determine how this agreement is going to impact your cash flow, your revenue goals. Your business strategy is going to clarify and to reflect how the contract is going to advance or undermine what you want to achieve with your business. You need to make sure that you've got a customer needs assessment to ensure that this contract is going to serve the needs of your customers, because after all, that's what your business is built on. And then you want to make sure that your contract is consistent with industry standards. And if you're differentiating, you do that with intention. Skip these foundations, and you might end up with a contract that looks great, but in fact is undermining everything you're trying to build. And that's the reason why if you're trying to put a contract together, the first step is putting together a term sheet or going through a strategic planning session to ensure that your contract is actually fit for your business and for your needs. After all, the most expensive legal advice is the kind that's based on bad instructions that in turn, when they're implemented, completely undermine what you're trying to build. So once you've done your strategic session, let's move on to what we call representations. Representations are the reasons why parties are coming into a contract. Often overlooked, they're frankly the most important part of the contract. These are the factual statements that are inducing a party to enter into a contract. If you're going to be saying that your service is going to increase the efficiency by a certain percentage, or you're going to be creating, or it's a good that's providing certain performance benefits health-wise, you are creating promises or legal obligations that are not simply marketing claims. These are expectations that you're giving to a customer that the customer is expecting to meet. And so the danger is the gap between what's sales language and what you're actually able to do. If you're overstating capabilities, you're undermining your relationship. And if you're underrepresenting your value, you're going to be leaving money on the table, and you might be losing clients to your competitors. That's the reason why, if you're in business, you need to be examining your representations carefully and specifically making sure that you're not over-promising and under-delivering. That's critical whenever you're running a business. You should always be under-promising and over-delivering, because again, that's the foundation to a happy client. So that's why, if you're thinking about this simply, the most expensive contract clause is one which you frankly is a promise that you can't keep. Now, once you've figured out what you're able to do and what you're able to deliver, we then will move on to what we call the business services element, the reasons why a party is paying money for you to deliver. You might offer bookkeeping services, but your customer is expecting you to deliver financial reporting. This mismatch in customer expectations are the reasons why so many disputes arise. If you are entering into a contract, you're creating a contract, you need to make sure that your contract is setting out exactly what things you're providing or receiving, so that there's no mismatched expectations, that all parties know what is to be delivered and what is not to be delivered. So here are three things you should be thinking about when it comes to contracts. So vague service descriptions mean that customers will have unrealistic expectations. If you are going to say marketing support, that's risk that is going to be really, really broad. Make sure that your clauses and provisions are defining three things very, very accurately. First, be specific with respect to your deliverables with outcomes that can be measured. Have performance standards that somebody else can verify. And then separate the services that are included with versus things that are not. Again, the clarity here isn't about avoiding disputes. It's really about setting expectations of what you are actually delivering. The third component of your commercial contract blueprint is money, because obviously everything revolves around money. But you might think that money is just about amounts, but frankly, it's about much more. It's about cash flow. It's about business sustainability. Here are a couple of things that you should be thinking about when it comes to contracts, when it comes to money. First, think about money as a reflection of your cash flow needs. So for example, payment timing is more important than payment amount sometimes if your business is growing. A $10,000 contract paid in a short time, let's say 14 days or 30 days, can often be more valuable than a $15,000 contract that's payable in 120 days. Okay, bird in hand is better than two birds in a bush, right? You also want to be thinking about risk and how to allocate risk in the event something goes wrong. This could involve stuff like late payment penalties, expense reimbursements, limitations of liabilities. Each of these things are appropriate when, under different circumstances, if things go wrong. And so that's the reason why before signing a contract, you've got to make sure that the contract reflects the financial terms that you need for your business. You need to be optimizing your contracts for business sustainability. So when it comes to restrictive covenants, the mistake so many business owners make is either not having any restrictions on conduct, or alternatively having restrictions that are so broad that they are unenforceable. Restrictive covenants are designed to protect a party's competitive advantages, but they're only enforceable as long as they're not reasonable. The key is understanding this difference. So let's go over some key provisions or key types of clauses when it comes to restrictive covenants. First idea is a non-solicitation clause that prevents a party from taking away customers or employees from another. These provisions are used to protect specific relationships that a party has built over time. You then have non-disclosure agreements that protect confidential information that a party has. This is the information that you do not want to become public. You then have non-disparagement clauses that prevent reputation damage both before, during, and after a business relationship. And you can even, in limited circumstances, have what's called a non-competition clause that prevents a party from doing competition within a certain geographic radius, as long as it doesn't prevent them from doing business, period. The mistake that so many business owners make is having no restrictions at all, or again, restrictions that are so broad that are unenforceable. Again, this is the difference between a non-compete provision that prevents someone from working in their field versus a non-solicitation provision that prevents someone from contacting your clients for a set period of time. You've just got to protect what matters most while being careful to ensure that everyone is left with room to succeed and make money. Every business creates intellectual property almost on a daily basis. However, most entrepreneurs and business owners aren't aware of it, and they're not capturing and protecting the value that's being created. Now, intellectual property clauses are really foundational to most service-based businesses. Businesses with clear IP ownership can license, franchise, and sell what new innovations they're creating. Those with unclear IP ownership can't. And so when you're thinking about these sorts of contracts, you need to be clearly defining three types of intellectual property. First, the existing intellectual property that a party is bringing into the relationship, the new intellectual property that's being created during the collaboration, and any confidential information that's shared between the parties. When these aren't clearly defined, that's when problems start. So if you're looking to build a relationship that involves the exchange or creation of intellectual property, you have to start by systematic classification. You first document what intellectual assets are going to be contributed to the venture. You've got to identify what innovations or intellectual property might be generated. And you should also be establishing who is going to own this new intellectual property before a legal dispute starts. Once a legal dispute starts, it's too late. Again, when it comes to an IP-based relationship, thinking about intellectual property strategically is going to create the foundation you need to build long-term business value. Virtually all contracts will have a term and termination section. And in this section, you're going to be highlighting what are the exit strategies that comes to an agreement. And these exit strategies don't always necessarily have to be contentious, but it is strongly recommended that you have an exit strategy, if not multiple. These term and termination provisions are about adapting to changing business needs, and a well-formulated termination provision will preserve valuable relationships, not destroy them. Term provisions should really be matching your business objectives. So a short-term project might want a duration-based term, like a 1 year, 2 year sort of thing. An ongoing relationship might have performance-based criteria. So if it's below the performance, that's when you can have the agreement end. A growth-based partnership might have an expansion trigger. Termination provisions, on the other hand, is about protecting everybody's interests when a relationship ends. These include notice periods, return of property clauses, post-termination obligations, especially when it comes to intellectual property, or restrictive covenants. The biggest mistake here is treating termination as purely negative. The best contracts will make ending relationships as professional and mutually beneficial as starting them. And they're often the foundation of a second, third, fourth relationship. Disputes are a possibility in every contractual relationship. And that's why most contracts will have a dispute resolution provision that will help business owners navigate the circumstance, the possibility of a dispute arising. Now, dispute resolution mechanisms are about how conflicts are going to be addressed before they become lawsuits. Now, inside dispute resolution provision, you're probably going to be talking about at least 3 types of things. First, whether the parties are going to have the ability to directly negotiate a resolution. Second, the possibility of mediating the resolution. And if a dispute cannot be resolved through mediation, the need for an arbitration that allows a dispute to be resolved without court delays or any publicity. The key here is matching the resolution method to the type of conflict. If it's something around intellectual property or confidential information, you don't want that to be resolved in court. You want to be resolved in a private dispute resolution process. The key thing to remember here is that the best dispute resolution mechanisms, they prevent a conflict from escalating into a really expensive court dispute. That's what the best dispute resolution mechanisms do. The commercial contract blueprint isn't really about making agreements more complicated. It's frankly about making them more effective. When your contracts are aligning with your business strategy and identified business and relationship objectives, you're building a foundation for more scalable growth. Think about your most important business relationship right now. Can you articulate how the agreement supports your strategic foundation? Are the execution elements, services, money, restrictions, IP terms, dispute resolution, are they aligned with your business needs? If you're uncertain about any of these elements, you've identified exactly where your business might be vulnerable. The good news is that with enough notice, like Batman, contract problems are completely preventable because you've understood the strategic framework that makes your agreement work. And if you need help with that, we've got our AI wizards, our contract brief AI wizards, that will help you address the strategic foundations and mechanics of your agreements before you even speak to a lawyer. You'll get clarity on what you need, and we'll get the information we need to craft protection that fits your situation. If that's something of interest to you, just drop contracts below and we'll be in touch on how to get access. Cheers.